Hello and welcome to today's webinar. My name is Robbie and I will be in the background answering any WebEx technical questions. We have a few housekeeping items before we get started. If you experience technical difficulties joining the WebEx session, please dial 1-866-779-3239, or you can message the WebEx producer using the Q&A panel. During the presentation, all participants will remain in a listen-only mode, and as a reminder, this event is being recorded. Time permitting, we will be holding a Q&A session at the conclusion of today's presentation. We encourage you to submit written questions at any time during the presentation using the Q&A panel at the bottom right of your screen. Please type your questions into the text field and hit send, and please hit the drop-down of all panelists. I would now like to hand it over to your first speaker for today, Don Zun. Don, you now have the floor.
Thank you, Robbie. Good morning, afternoon, evening, depending on where you happen to be logging in. We're going to try something a little bit different than what we normally do for our MBHB webinars. Given the global pandemic, we're all calling in from remote regions and not sitting in a single office in downtown Chicago. And also, for the second time, we're going to be doing a joint presentation with a few European patent attorneys. So what we have speaking today, well, I'm Don Zun. I'm a partner with McDonald, Bennett, Holbert, and Berghoff, and I'm located out in the Chicago suburbs. Also with us today, Sarah Fendrick, who's a partner with me at MBHB and also in Chicago. And then we have Charlotte Peel, who's a partner with Forresters, and she's in London. And Simon O'Brien, who's a partner with DUN, and he's also in London. And before I turn it over to Sarah, who's going to talk first, I also have some housekeeping item. And so bear with me. Please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note that there are two randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we will attempt to address submitted questions at the end of the webinar, or maybe even a couple of questions during the webinar. If time does not permit, we will respond offline after the webinar. What we normally do is do something on the Patent Docs weblog to answer questions if we run out of time. So don't hesitate to send your questions in. We will get you answers in one way or another. So let's move to the first slide and get a little roadmap of what we're going to cover here. So Sarah's going to talk about patent term adjustment and patent term extension, obviousness-type double patenting, and terminal disclaimers. Then I'm going to talk about some Federal Circuit patent term adjustment decisions, and then the intersection between the Patent Law Treaty and PTA. Then Charlotte's going to talk about double patenting, novelty only, prior art and disclaimers, and priority. And then we'll save the best for last. Simon's going to finish up with added matter trap and plausibility. And so without further ado, let me turn it over to Sarah, who's going to talk about the first topics on the roadmap there.
Good morning, everyone, and thanks for joining us. So today I'm going to talk about predominantly patent term adjustment. So in the U.S., there are two patent terms that are available. So for applications that are filed before June 8, 1995, those are going to have a term of 17 years from issuance. And then for those applications that are filed on or after June 1995, those are going to have a term that begins when the patent issues and ends 20 years from filing. So in addition to the 17 years and 20 years, that term can be extended through two main mechanisms. So the first is patent term adjustment, and this is going to compensate applicants for delays that occur at the patent office during examination and issuance of the patent. And the second one, or the second mechanism that can extend patent term is patent term extension. And this is going to be available on applications and patents that are subject to regulatory approval. So pharmaceutical and other products that have to go through pre-market approval can apply for PTE to extend a patent term. So the total patent term will be that 17 or 20 years, plus any PTA that's been accrued, plus any PTE that's available. So I'm sure everybody's heard a lot about patent term adjustment at the U.S. Patent Office. So I'm just going to briefly go over the 3 periods of delay that can occur on the PTO's part. So the first is the A delay. This is going to be if the Patent Office fails to respond promptly. There's a number of categories that can fall under this and to accrue A delay. B delay is going to occur when the patent doesn't issue within 3 years from the filing date. And then C delay is going to be for other adjustments such as interferences, secrecy orders, and appeals. And so the total patent adjustment that an applicant can accrue during prosecution is going to be a combination of A, B, and C delay. So in instances where an applicant does accrue patent term adjustment, which is not always the case, there are times where the Patent Office works timely and, the application is not subject to any patent term adjustment. But when there is, the applicants going to want to maximize this PTA so that their patent term is extended beyond that 17 or 20 years. And so in order to maximize the PTA, there are a number of things to consider during prosecution as an applicant. And the first is going to be timely reply to actions within 3 months after the action mailing date. So avoid extensions of time where possible, because any extension of time that's taken is going to take away from any patent term that's accrued. Avoid incomplete replies or submissions of supplemental replies. And one instance of this occurs with information disclosure statements. So when an IDS is filed after a response to an office action is filed, and it's filed without a certification under 1.97E, it's going to be considered a supplemental reply. So instead of filing the IDS at that point, a good time to file an IDS would be before receipt of a first office action, with a reply to a non-final office action, or in instances where the application is also in foreign prosecution and there's a reference that's been cited in a foreign application, within 30 days of receiving that foreign action. And then that reference can be submitted on an IDS with certification under 1.97E, and that will avoid taking away any patent term adjustment that's been accrued by the applicant. Other ways to maximize PTA is to avoid filing RCEs where possible. When an RCE is filed, it's going to stop the 3-year clock under the B delay. Avoid submissions of papers after notice of allowance, and avoid filing unnecessary terminal disclaimers. So I will get into the terminal disclaimer aspect in a little more detail in my next topic with regards to double patenting. But really, if an applicant does accrue patent term adjustment, just keep in mind during prosecution to act in a timely manner so that the term of the patent can be extended as far as possible and provide the maximum amount of protection to the invention. So now switching gears, I'm going to move to double patenting. So non-statutory obviousness double type patenting is going to prohibit claims in a later patent that are not patentably distinct from claims in a commonly owned earlier patent. So this is a judge-created equitable doctrine, and the reason for it is there's really 2 principal concerns that double patenting addresses. And the first is that without it, a patentee would be able to effectively increase the patent term by filing, multiple patents on not necessarily the same exact invention, but embodiments that are not patentably distinct. And so double patenting eliminates this concern. And the second concern is going to occur when an accused infringer, without double patenting, they'd be potentially subject to multiple infringement suits from different patent owners. And this would be because an accused infringing article could potentially infringe claims of multiple different patents. And so through the double patenting doctrine, both of these concerns are addressed. So there's a number of general conditions that must be met in order for an examiner to issue a double patenting rejection during prosecution. As I discussed earlier, the claims in an application that are under examination are not going to be patentably distinct from claims in another application or patent. So this doesn't require that the claims are identical. It's just that the claims are not patentably distinct. Another condition that must be met is that the application under examination, it must share a common joint inventor, applicant or assignee owner, and even in instances where there is not that joint inventor or common applicant or common assignee or owner, it can still apply if there's a joint research agreement that's involved between the parties. So when double patenting is asserted or applied, there's two different types of analysis. There's a one-way obviousness and a two-way obviousness analysis. So the one-way obviousness is going to apply if the application at issue is a later filed application, or if that application and the earlier application are filed on the same day. And this is going to look at the obviousness of the claims over those of the patent. So it's only going in one direction as far as the obviousness analysis. The second is two-way obviousness, and this is going to apply for applications that have an earlier filing date, in instances where the applicant could not have filed the patented claims in the earlier filed application, and where the delay is solely responsible, the administrative delay is solely responsible for the earlier filed application not issuing first. And so this analysis is going to require that the application claims are obvious over the patent claims, and the patent claims are obvious over the application claims. So it's a two-way analysis. So when an applicant receives a double patenting rejection during prosecution, there's really two ways to address it. And the first way would be to argue against it and argue that the claims are patentably distinct and not obvious over one another. And oftentimes, however, this isn't necessarily going to be an available option. And the other remedy would be to file a terminal disclaimer. So a terminal disclaimer, when it's filed, will disclaim a portion of the term of the later issued patent that would extend beyond the expiration of an earlier issued patent. And this is going to occur again when the claims are not patentably distinct. So terminal disclaimers will preclude alienation for those patents because there can't be separate ownership in which the terminal disclaimer is filed. So when a terminal disclaimer is filed, it's going to apply to all the claims in the patent. So even if the examiner has only issued a double patenting rejection on a portion of the claims during prosecution, once that terminal disclaimer is filed, it's going to disclaim the term of all the claims in the patent. A terminal disclaimer will obviate the rejection, but it doesn't overcome the rejection. And when a terminal disclaimer is filed, there is no estoppel that is created by it. But one consideration is that a terminal disclaimer can only be filed in instances where the earlier patent and later application are co-owned. So when a terminal disclaimer is filed, some considerations is, has the patent term been extended either through PTA or PTE? And in instances if the application or patent has patent term adjustment accrued on it, the filing of a terminal disclaimer is going to wipe that out and negatively affect that. However, with regards to PTE, so those applications or patents where that claims are subject to regulatory approval, the terminal disclaimer is not going to affect that. So it will leave intact any PTE that has been accrued on the patent. So those are some considerations when you get a double patenting and deciding whether to file a terminal disclaimer or not. So when can terminal disclaimers be filed? Most oftentimes it's going to be filed during the pendency of a later application in response to double patenting rejection issued by the examiner. However, terminal disclaimers can be filed in post-grant. Oftentimes it's going to happen during litigation where a claim has been, challenged on validity because of a double patenting issue. And so in response to that, the party can file a terminal disclaimer to get rid of that challenge. However, in order for a terminal disclaimer to be filed in this instance, the earlier patent must still be pending. It can't have expired because as soon as the patent has expired, the earlier issued one, a terminal disclaimer can no longer be filed at that instance to address a double patenting rejection or a challenge. And before filing a terminal disclaimer, as an applicant, you want to make sure that this is really the route you want to go because it's not easy once the terminal disclaimer is recorded to withdraw it. A petition can be filed to withdraw a terminal disclaimer as long as it's during prosecution, but in order to do that, the petition must provide grounds to why the terminal disclaimer is no longer required. And then once an application issues as a patent, it's nearly impossible to withdraw recorded terminal disclaimer. Your certificates of corrections, reissues, reexams, IPRs, and CBMs are not an available option that can be used to nullify any recorded terminal disclaimer. So in addition to filing a terminal disclaimer, another consideration with double patenting is the safe harbor provision. And this is going to apply when a restriction requirement has been issued. And this restriction requirement can provide a safe harbor. So in applications where the office has issued a restriction requirement, this is evidence that the office has determined the claims to be patentably distinct. So in order for a later application to be subject to the safe harbor provision, these later patent claims or application claims must be within the scope of the groups that have been identified in the restriction requirement in order to be patentably distinct and then to be subject to the safe harbor. In addition, the Federal Circuit has weighed in on the safe harbor and what the limitations are on it. The Federal Circuit has indicated there's certain formality and substantive features that must be present in order to qualify for this safe harbor protection. And specifically, the Pfizer versus Teva case, it's a Federal Circuit case in 2008, limited the protection of the safe harbor or the statute to only divisional applications. So this is a case where the application pending was a continuation in part and included differences in the specification. And the party argued that the continuation in part should also be subject to safe harbor protection. However, the court found that the statute language and legislative history both indicated that this safe harbor provision was limited only to divisional applications. In another Federal Circuit case in 2010, Amgen versus Hoffman, again, the issue here was what could the safe harbor provisions be applied to? Here was a continuation that was at issue. The district court thought that the safe harbor provision shouldn't be limited just based or dependent on properly ticking of a box, but the Federal Circuit disagreed and reversed and found that the reference patent must actually be labeled a divisional and not a continuation or continuation in part. So even in instances where a continuation could have been filed as a divisional, that wasn't enough. It actually must be labeled as a divisional. And then additional cases further expounded on this and indicated that this divisional status that's required in order to be subject to the safe harbor must be established during examination and can't be corrected at a later date. So based on all of this, really with regards to double patenting, some considerations are, in instances where you don't need to file a terminal disclaimer, and you can argue against it, that's probably the route you want to go to avoid any negative effect on patent term extension. And then also in instances where you can file a divisional application, go ahead and file that divisional application because it's going to bring you into the safe harbor provision and prevent against double patenting rejections. So at this point, if everybody can take a look at the screen and you're seeking CLE today, if you could enter in that one word on the screen into the poll to get your CLE credit. And with that, I'm going to turn it over to Don.
Thanks, Sarah. So why don't we just stay here for a few more seconds to give everybody a chance to enter the poll word. Again, the word is traps. Okay, so hopefully you got that poll question in. Again, the word is traps. One thing I neglected to mention, given that we have a global pandemic, I hope everybody in our audience and all your family and friends are doing well and staying safe. And now let's talk about patent term adjustment. I think many practitioners, well, a little bit more about patent term adjustments, and Sarah talked a lot about it as well. I think a lot of practitioners probably don't realize that patent term adjustment's been around for 20 years now. It actually came into being in the American Inventors Protection Act in May of 2000, started impacting applications that had been filed in May of 2000. So we just passed up the 20th anniversary. And like IDS practice, it's something that's fairly unique to U.S. patent practice and very complex. We could probably do a full day of patent term adjustment webinars just going through the process. Nice overview by Sarah, but it's a very complex process, and there's a lot of tiny little traps in the big trap that is patent term adjustment. And the complexity of the system, I suppose, is reflected on this list of Federal Circuit decisions that we've seen over the last 10 years. And many folks are familiar with Wyeth and the overlapping A and B delay issue that came out of that. But we've had decisions almost every year that have gone all the way up to the Federal Circuit to figure out little nuances of the system. And so I'm going to go over, there's a dozen cases here, and I'm going to talk about 7 of them in an overview, just go over them briefly. So in the first 2, we're going to talk about restriction requirements and responding to restriction requirements and when a restriction requirement has a defect. So in this first case, we have a situation in which the examiner not once but twice reissued a restriction requirement to include subject matter that the examiner had omitted in the first and second restriction requirements. And this omission was brought to the examiner's attention by the applicant, but the applicant did or did not do one thing that the applicant probably should have done, which was to elect an inventive group. And so one of the themes you'll see here is that a good successful practice for PTA and IDS practice for that matter is to not put off till tomorrow what you could do today. And I know that's easier said than done, and we're all juggling dockets and things slip through the cracks, but try to get things done sooner rather than later, and you may not find yourself in a situation where you've got an unusual PTA or IDS situation. So in this case, the applicant sought a reconsideration with the Patent Office, and the Patent Office determined that the second restriction requirement, not the first or third, stopped accrual of office delay. And I think the reason for that was that the first restriction requirement identified 6 inventive groups, and because of the omitted subject matter, the second one came up with 8, and the third one also had 8. So the applicant challenged this PTA determination in the district court, which is the way you challenge PTA determinations. And the district court remanded back to the Patent Office for reconsideration in view of Pfizer v. Lee, which we'll be talking about next. And on remand, the Patent Office determined that it wasn't the second restriction requirement, it was actually the first restriction requirement that stopped accrual of the office delay. And this went up to the Federal Circuit. The Federal Circuit affirmed and finding that the first action satisfied the notice requirement of Section 132. And the Federal Circuit's rationale was that the applicant knew enough about the problems with the restriction requirement in order to oppose it. And I guess the take-home message is if you're going to rely on the examiner to reissue, you probably should respond to the first as best as you can to the first action, whether it be a restriction requirement or an office action. Moving on to Pfizer, we have another case with a restriction requirement that had an omission. In this case, the examiner only needed to reissue it once. And again, just like in the first case we talked about, the applicant had brought to the examiner's attention the omission of several claims and didn't elect an inventive group. And in this case, the Patent Office said that it wasn't going to count the time between the first restriction requirement and the issuance of a corrected restriction requirement, which was 197 days, as office delay. Applicant didn't like that and challenged it at the district court, which granted summary judgment in favor of the Patent Office. The Federal Circuit affirmed, and as in the first case, found that the first action, the first restriction requirement, satisfied the notice requirement of Section 132. And here was a little more straightforward. The Federal Circuit explained that the 6 omitted claims were dependent claims, and the independent claims from which they depended were in groups that the examiner had designated. So in the Federal Circuit's opinion, the applicant could have responded to the first restriction requirement. In this case, Judge Newman wrote a dissent and made some good points, but the plurality in the Federal Circuit took the day on that one. Let's talk a little bit about what happens when you have office action and how you need to respond to that. So we have Intra-Cellular Therapies. Here we have a final office action that was issued, and the applicant presented the same arguments that had been previously found by the examiner to be unpersuasive. The examiner issued an advisory action, suggested some claim amendments and some claim cancellations. And 21 days after filing the first response, so it was pretty quick advisory action, the applicant adopted the examiner's suggestions in the advisory action and responded. And the Patent Office determined that the 21 days between the first and second responses constituted applicant delay. The applicant didn't like that, challenged the case to the district court, and the district court granted summary judgment to the office. When this got to the Federal Circuit, the Federal Circuit had to determine whether the Patent Office's interpretation in this case was entitled to Chevron deference. And here the Federal Circuit decided that the office's interpretation was reasonable and that the applicant just repeating arguments in the first response to the final office action didn't constitute, and these are the magic words in PTA, were a failure, constituted a failure to engage in reasonable efforts to conclude prosecution. So that's the key. You have to engage in reasonable efforts to conclude prosecution to avoid having any issues. Moving on to the next case, here we have an interesting situation in which the applicant responded to a final office action by filing an RCE, and then after filing that RCE, they received an opposition notice, and 100 days after receiving the opposition notice, they filed a supplemental IDS. So if you're familiar with the basics of PTA and IDS practice, filing an IDS after an RCE is going to get you in trouble with PTA unless you just receive those references. And in this case, the issue was that the Patent Office determined that there were 646 days of applicant delay between the filing of the RCE and the filing of the IDS. The applicant didn't like that, challenged it to the district court, which again found in favor of the Patent Office. In this case, however, the Federal Circuit reversed and remanded, and they concluded that that the PTA reduction was inconsistent with the PTA statute. And so here, what the Federal Circuit said was that the office can't count as applicant delay a period of time in which the applicant couldn't do anything. And so the 546 days from the RCE to the opposition notice can't be counted against the applicant because the applicant couldn't take any action until receiving the opposition notice. But the 100 days after receiving the opposition notice, that could be considered applicant delay. Moving on to the next case. Here we have a case where we figure out how PTA works with national stage commencement. And so the old rule was that if you didn't start the 14-month clock for the office to issue a office action on the merits until you completed your 371 requirements. But that got changed a couple of years ago so that it starts with the 14-month clock starts with commencement. In this case, the 30-month commencement date was a federal holiday, Martin Luther King Day, January 16th, and the applicant had anticipating that holiday, had filed or entered national stage 4 days earlier on January 12th. So, we have two issues here. One, an early commencement, and two, the commencement falling on a holiday. And also the applicant inadvertently, I'm assuming, forgot to check the box on the transmittal letter requesting early examination. So the applicant was upset about losing 5 days of PTA, and yes, that isn't an infrequent occurrence. Everybody might remember our Arcule case from more than a decade ago, where just 1 or 2 days was at issue there for responding to an office action. So this happens occasionally, and in this case, the office denied those 5 days and determined that the commencement date was the day after the national holiday, January 17th. The applicant didn't like that, challenged the district court, which again found in favor of the patent office. And the Federal Circuit affirmed in this case, finding that both the finding of no express request and that determining the commencement date started the day after a federal holiday were the right decision, and saying, moreover, that inaction on a holiday is not attributable to the PTO. So I guess that this case here raises a second issue. Not only do you want to not put off what you can do today until tomorrow, but you also want to be very careful, because little things like checking a box could result in lost PTA. And again, we're all human, and these kinds of things happen, but you just want to be careful. And maybe a second set of eyes is not a bad idea, just to make sure that there aren't any issues that a practitioner hasn't realized. On this next case, let's talk about what happens in related applications or related patents with respect to PTA granted in an earlier parent. So here we have two patents at issue, and they both have a common parent. In the parent, the Patent Office took 5 years after filing to issue a restriction requirement. And so we're well past the 14-month period of time in this case. In fact, we have almost 1,500 days of PTO delay in issuing the restriction requirement here. So the applicant filed 2 divisional applications with claims that corresponded to inventions that had been identified in the restriction requirement issued in the parent patent. And if you're familiar with consonants, and we could be, again, we could do probably a half hour on consonants alone, you have to have a restriction requirement issued in the case that you're prosecuting or in the immediate parent in order to maintain that consonants. And be entitled to, proper safe harbor and not have to worry about obviousness-type double patenting issues like some of the ones that Sarah had talked about earlier. So in this case, both these patents issued and they had 0 days of PTA. The applicant wasn't happy with this and wanted 1,500 days of PTA in both of the patents, the divisional patents, and requested reconsideration, which the Patent Office denied. The applicant went to the district court, which again granted summary judgment in favor of the Patent Office. So you may be sensing a theme here with the district court. And the district court found that Section 154 requires that PTA apply to delays that occur during the prosecution of the actual application from which the patent issues, not a related one, not a parent. And the Federal Circuit affirmed and said essentially the same thing, that the plain language of Section 154 does not provide for PTA in continuing applications based on delays in the parent. So the last case that I wanted to talk about is Gilead. And so here we have another restriction requirement case and also some IDS practice. So here we have a restriction requirement that's issued, and Gilead filed an IDS 57 days after responding to that restriction requirement. The Patent Office mailed a non-final office action 27 days after the IDS was filed. So there was a period of time there where the examiner presumably knew about the references on the IDS. And when it came time to determine PTA in that patent, the office docked the applicant 57 days, asserting that the IDS, which was a supplemental response, constituted a failure to engage in reasonable efforts to conclude prosecution. Again, that phrase that we've all become very familiar with. And in this case, the applicant argued that the subsequent IDS did not cause any actual delay. And that was the issue. Here is 1.704C8. And so 1.704C provides a list of the types of behaviors that are going to cost you PTA, and this is just one of them. And in this case, the submission of a supplemental reply or other paper after a reply has been filed is going to cost you PTA. That's considered to be a supplemental response. And so the idea is that unless you had just received the references and filed a 704D statement, which I think Sarah mentioned, 30-day statement, you're going to lose PTA in this case if you file the IDS at that time. So again, the applicant thought that there was no actual delay, and they challenged the determination to the district court, which granted summary judgment in favor of the Patent Office. The Federal Circuit affirmed, again, looking for whether the Patent Office is entitled to Chevron deference. And here, the Federal Circuit said that the applicant was focusing a little bit too much on its own situation and not thinking about the examiner juggling his or her own docket and all the things that the examiner would have to handle. And so while there might not be an actual delay in this case, it could have presented problems in other cases. One other section is C6, and I'll let you look at that on your own. And the one last thing that I wanted to talk about was the intersection between the Patent Law Treaty and PTA. So the Patent Law Treaty is one of my favorite treaties. Took a long time for it. It's a WIPO treaty, and it took a long time for it to get put in place here in the U.S., as you can see from the timeline. It has a lot of nice stuff in it, not the least of which is being able to file a non-provisional application without claims and or by reference to a previously filed application. And one issue that it raises then is that these changes allow the applicant to delay examination, because if you have no claims, you can't, there's nothing to examine until we have claims. And so the Patent Office has decided that you have 8 months from filing or commencement to put the application in condition for examination. And if you don't, then you start getting docked to PTA. So again, if you file an application without claims, and there's a lot of good reasons to do that, not the least of which is transition applications coming out of the AIA, which is another trap to be careful about. If you do that, you want to make sure that you get your claims and your application in condition for examination within 8 months of the filing or commencement date. And so now I want to turn it over to Charlotte to talk about some European issues. So Charlotte, take it away.
Thanks, Don. Thanks for joining, everyone. So I'm now going to transition over to European law and some aspects that are relevant and quite recent in the European sphere. So I'm going to cover double patenting, novelty-only prior art and disclaimers, and also self-collision. And the most famous example of that is the poisonous divisionals decision that came out in the last couple of years, and then finish with priority before Simon takes over on some other aspects. So firstly, dealing with double patenting. First thing to note, there's no provisions in the EPC on double patenting. But like in the US, there is an equitable doctrine that's developed in the case law, and it's a generally accepted principle that a single applicant has no legitimate interest in the grant of 2 patents for the same subject matter. So you will see that objection from an examiner where you have identity in subject matter. It's a pretty narrow objection, and if you've got any difference in your claims, you can normally argue that they are not same subject matter. For example, quite often you have overlapping scope, and there you're deemed to have a legitimate interest. For example, where you have a parent divisional relationship, and in your parent you pursue a narrower commercially important claim to grant quickly, and then you file your divisional to the broader claim. That is fine under European practice. More recently, the questions have come as to whether there is any legitimate interest when you do have identity in subject matter, same subject matter. So previously there was the parent divisional relationship considered in G1 of 05 and G1 of 06, and that was found that there is no legitimate interest in a parent divisional relationship. Well, we have currently a pending enlarged Board of Appeal referral in G4 of 19, which deals with a slightly different situation where there was identity in subject matter between a priority EP application that was granted to the applicant, and then they filed claiming priority in EP application from that, and it had same subject matter. And they argued, this is a case of internal priority, they argued in that case that there was a legitimate interest because their later EP application would have an extra year of protection, patent protection, because of its later filing date. So the Board of Appeal, looking at this before they referred the questions up, looked at the case law, and they said that they could only grant that second patent if the principle laid down in G1 of 05 and 1 of 06 is only specific to parent divisional relationships and doesn't apply to other types, such as internal priority in this case. And they also looked at the case law related to situations where there's an internal priority issue and whether the Board of Appeal had granted cases like that before. So looking at the first point, they looked at the obiter dictum in G1 of 05 and G1 of 06, and they decided that the legitimate interest principle is a broader legal principle and should apply also in cases of internal priority. And then they looked at 2 previous cases where a priority claim was involved in internal priority. And in the first Board of Appeal decision, the Board of Appeal said that there is a legitimate interest in this extra year of patent protection, but ultimately in that case the applicants were different, so there was no double patenting. So it wasn't decided on that point, it was decided on the fact that the applicants were different, so there was no double patenting. In T2461 of 10, there was only overlapping subject matter, so again there was no double patenting there, but they noted that they didn't think it was legitimate, this extra year of patent protection. So we have these conflicting decisions. So the Board of Appeal felt that they should refer questions up, essentially asking whether this principle, where you've got identity and subject matter, also applies to cases where you have internal priority, and that extra year, is that extra year of protection a legitimate interest? They also threw in parallel filings as well as another scenario, just to try and cover all bases so we get a clear decision out of it. So in summary, the EPO position is it's only same, not overlapping subject matter where you get a double patenting issue, and it's only same applicants in respect of the EP, but you need to be careful with that if you have different applicants and same subject matter, because some national laws prohibit that in terms of double patenting. So when you come to validation, for example, in France, you could face issues there with double patenting. It definitely applies to parent divisional relationships based on earlier case law, but it's now looking to clarify whether that also extends to internal priority and also parallel filings. One thing to note is that double patenting is only available as a pre-grant objection. It's not a ground of opposition. So if you want to allege it against a patent application, you need to do that in third-party observations before grant. And just a small note that the old Swiss-type medical use claim is deemed a process claim, and the EPC 2000 medical use claim is a purpose-limited product claim, so they have differing scopes. You will not get a double patenting objection if you have those two same claim types in different patents. So now moving on to novelty-only prior art and disclaimers. So many of you will be familiar with this concept in Europe that if you have an earlier EP application with an earlier filing date but a later publication date than another EP application, that earlier EP application will be citable as prior art but only for novelty. So there's a couple of conditions there. One, that earlier application must be an EP application, so it can't be a US application or anything like that. It can either be via the direct or Euro PCT route. It must eventually be published to be prior art, and for the Euro PCT, it must have validly entered the European regional phase. Then at that point, it becomes citable for novelty only, and an important point is it's the whole content of that earlier application that's part of the state of the art, not just any claims in that earlier EP application. So this is just an example of that. So you've got an earlier EP disclosing hydrochloric acid. That anywhere in that application that will be citable against the later EP in the Article 54.3 situation where you have a claim to strong acids, so that will be anticipated by the hydrochloric acid disclosure. So what can you then do about that? We've developed over the years case law on what you can do in that situation, and a disclaimer is applicable. The disclaimer case law has developed quite a lot over the last few years, and it's kind of beyond the scope of this presentation, but there's some information there on the other types of disclaimer. But in terms of an Article 54.3 situation, this is really one of the only situations where you can include a disclaimer that doesn't have basis in the application as filed. As you know, the EPO is very hot on added subject matter, but in this case, you can include a disclaimer to disclaim the anticipated subject matter, but you must make sure you only exclude the anticipated subject matter and nothing broad, otherwise you can get into further added matter issues in that situation. And some of the other case law and disclaimers decided that you need to look at what remains in the claim after you've taken out the disclaimed subject matter, and that must be clearly and unambiguously disclosed. But a recent decision confirmed that that doesn't apply in this Article 54.3 situation. You're just allowed to disclaim without basis any anticipatory subject matter. However, we normally suggest that you go for a positive limitation if you can, because that just avoids any other added matter issues that crop up. And particularly in the case of Article 54.3, you only need to put a minor feature in there. It doesn't need to be sufficient to confer inventive step because it's a novelty-only objection. So this principle under Article 54.3 doesn't refer to any type of applicant between the two EPs. So it could, in theory, apply if you have the same applicant between the two EPs or different applicants. And this is where the concept, in the case of the same applicant, the concept of this poisonous divisionals came about. But actually there are three types of self-collision that could occur. One is this parent-divisional relationship where it's a poisonous divisional situation. One is where you have parallel filings and a common priority, and you make a claim amendment in one, and one loses its priority claim. And that could be a poisonous parallel filing, and then another where you have an EP priority application and a later EP priority claiming application, and you make a claim amendment and one loses their priority claim. That could become a poisonous priority situation. So G1 of 15, the Enlarged Board of Appeal looked specifically at the parent-divisional relationship, and as many of you will know, they found that there is no poisonous divisional situation. But what is interesting is they looked at priority and the substantive aspects, and essentially when you're looking at priority, it's same invention, which means same subject matter that you're looking at as to whether that priority is valid. And you can have partial priorities. So this is just a slide to show that principle where in the parent, if you have these broader claims that don't have priority, and then you have your divisional with the narrower claims, your divisional can then poison, in theory, your parent application claims by their specific disclosure. But the concept was based on an enlarged Board of Appeal decision G2 of 98, which discussed partial priorities. And the conclusion was that you can have multiple priorities if the claim is limited to a number of clearly defined alternative subject matters. So this was assumed then to mean that you can only have partial priorities for all claims with literally defined alternatives, which led practitioners to consider splitting a claim, a general claim, using an Article 54.3 disclaimer. So for example, you had a claim to a composition comprising any metal. A specific disclosure of a metal is aluminium. So you split your claim into a composition comprising any metal except aluminium, so that's your disclaimer part, or the metal being aluminium. And then it became a question of whether that was just a substance over form and should you need to amend your claim, or can these partial priorities apply in the case of a generic claim to just a composition comprising any metal. And happily, the enlarged Board of Appeal said, yes, a generic claim may enjoy partial priority for the alternatives specifically disclosed in the priority document. So your claim is conceptually divided into two parts, and therefore there is no self-collision issue there. And it's generally held that this principle applies across the range of self-collision situations to cover all of them. Which was good news in terms of EPO practice. There is one slight wrinkle in that the UK had a High Court decision before that in Gilead, where they had this poisonous priority situation based on a UK priority and UK priority claiming application. So under UK law, there are equivalent provisions under Section 2.3 to Article 54.3. And in that, the High Court found that there was a poisonous priority issue here and the claim fell down. And our current guidance is that decisions of the Enlarged Board of Appeal are not binding on UK courts, but are persuasive. But in the meantime, UK IPO examiners remain bound by the approach in Nesteg. So that may well change as the case law develops, but it's just something to be wary of with UK practice. And another point that stems from this decision was highlighted in the Board of Appeal decision T282 of 12, which concerned U.S. continuation in part practice. So a consequence of this partial priority decision is that an earlier U.S. application could be the first application for part of that subject matter that has priority. And as a result, if that's outside the 12-month period, it can cause that partial subject matter to only enjoy the filing date and not the priority date. So in the case, they had their EP had a range of 3 to 33% of length of a tablet in terms of the tablet structure. The continuation part that they claimed priority to within the 12 months disclosed that same range, but there wasn't the earlier US application of which the continuation part was a continuation, disclosed the narrow range of 5 to 33% and all other features. And it was found that it was confirmed that the US earlier application gave rise to the priority right for that range of 5 to 33%. And because that was earlier than 12 months before the EP filing date, then that meant that its effective date was the filing date. And the only valid part of priority was the 3 to 5% range. And the prior use of 17% was then deemed relevant. So that's just something to be wary of to make sure, and I think it's probably pretty standard practice now to make sure that you file your EP or your PCT within the 12 months of your earliest US application. So then moving finally on to priority. So there are two aspects of priority, substantive and legal, and for the substantive side, we've covered that with the earlier slides, and essentially it's same invention, same subject matter, and it doesn't need to be in the claims of the priority document. You can consider the whole content, and there are partial priorities possible. What has been quite contentious more recently, is the legal aspects of priority. And this stems from the provisions that say any person who has duly filed an application for a patent or his successor in title shall enjoy, for the purposes of filing a European patent application for the same invention, a right of priority during a period of 12 months from the date of filing the first application. Where the contention has arisen is in relation to the any person wording. So the recent CRISPR cases involving the Broad Institute, the patentee, have caused some issues with the priority claim. There were 12 priority documents, and it was generally understood prior to this case that any person means all applicants named on the priority document or their successor in title, not just one or two. And in their case, the opposition division found the priority claim invalid because one applicant named on some of the earliest priority documents was not named on the PCT application. And so the EP was revoked because there was intervening prior art that anticipated the subject matter. The patentee's three main arguments on appeal were that the EPO is not competent to assess it. It should be dealt with by the national courts, and any person should be interpreted as at least one instead of all. And it's the national law of the territory of the priority application that should dictate the interpretation of any person. So in that respect, they referred to the fact that under US law, the person who's filed the provisional application as the first application is the person who's contributed to the invention. And where the US provisional, as in that case, disclosed multiple inventions, some applicants and some inventors have not contributed to that. And so US law should be decisive in assessing who has duly filed. But the opposition division disagreed, and they said under the Paris Convention, it really looks at the right to claim priority, looks at the formal filing of the first application, irrespective of the status of the inventor. So it's a legal point, not who's contributed. So we're waiting for the full decision on that, but the Board of Appeal has basically said that the EPO is competent and that any person must be interpreted as all applicants. So they confirmed the decision to revoke. We're waiting for their full decision, but really this highlights a situation where you need to ensure that on your PCT application that you're claiming priority, that you ensure that all of the applicants, as in scenario 2 here, are listed as applicants on the PCT that were on the priority. So there's at least all of them on there. And if one has transferred within the year, then you can, within the priority year, then you can name them in place. But if they haven't, you should record the transfer after and name all of the applicants. And so currently the EPO views that where joint applicants are given on a PCT application, they are joint applicants irrespective of the designation. So this is quite an important point for US practice, in that if you have different applicants for the US as the remaining states, that doesn't matter currently because they don't split designations. So as long as you have A, B, and C named, that counts across the board. So your priority claim is valid there. And there's really making sure that you've got a valid transfer in place. So although the EPC does refer to employment rights, and if the transfer occurs by employment, we still recommend that you have a formal written assignment in place to make sure there's a valid transfer before the PCT application is filed, so in that priority year. And so this is everyone who is seeking CLE, this is your second slide to make sure that you put the word into the poll, and we'll give you a little bit of time on that before I hand over to Simon. So this is just a reminder to make sure that if you would like CLE to put the word traps into the poll right now in the next 20 seconds or so before I hand over to Simon.
Also, I just take the time before Simon starts to let you know that we've received a lot of questions. I don't think we're going to have time, so we'll probably address those questions on the Patent Docs weblog after the seminar.
Thanks, Don. Okay, so I shall be wrapping up the webinar with two issues that can be problematic under European practice that you should be aware of. The first is the added matter trap, and the second is this concept of plausibility. So the added matter trap involves two articles. Article 1232, which stipulates that neither the application nor the patent may be amended in such a way that it contains subject matter that extends beyond the content of the application as filed. In other words, the application can't contain any added matter. And it's important to understand that under European practice, the priority document and the abstract cannot be used as basis for an amendment. And the second article is Article 1233, which stipulates that the patent may not be amended in such a way as to extend the scope that the patent confers. So this isn't to do with added matter, but this is meaning that you can't broaden the scope of the claim post-grant. And so you can fall into the added matter trap if the scope of an independent claim is narrowed by an amendment that uses added subject matter. So if during prosecution you make an amendment to your, for example, claim 1 that narrows the claim, it proceeds to grant, but that amendment was actually associated with added matter. If the patent is challenged post-grant by an opponent for added matter, you can end up in a tricky situation because you can't remove the term without extending the scope of protection. And so you're in a position where your patent is essentially invalid because of a narrowing amendment you made during prosecution. This doesn't apply to an amendment of a dependent claim, and it also wouldn't apply if you're broadening the claim scope and the way you're broadening the claim may be a little bit iffy for added matter. It's potentially worth the risk because in opposition you could always revert back to your claim as originally granted, but it very much applies to a narrowing amendment. And this is an example of an applicant falling into this trap. The patent related to a package for topical administration or application of a composition under the armpit. And you can see on the right here, this is a typical ballpoint type deodorant. And at the end of the claim, it said that the side wall converged towards the front side wall to form a waist, and thereafter diverging outwardly beyond the base footprint to form a support. So essentially it's saying that one of the side walls goes in and out, as you can see in this diagram. But there is no basis for the term base footprint in the application as filed. There is only basis for the term base. Nevertheless, the application proceeds to grant with this term. The patent was opposed and revoked, and the proprietor appealed. And the board held that indeed the term base footprint did add matter because the base footprint had a different meaning to base. The base footprint could be a wider area of the base than just the base. And here the applicant couldn't change the word base footprint to base, which was in the application as filed, because in doing so they would extend the scope. But so the lesson here is that by this seemingly harmless amendment that the applicant made during prosecution, they end up with an invalid patent that was revoked. And so the practice notes are here. As many of you will be aware, the European Patent Office is very strict when it comes to added matter. If you're making an amendment that is narrowing an independent claim, think carefully before making that amendment that it won't leave you vulnerable in a potential opposition further down the line. Okay, the second concept I will briefly talk about is plausibility. And this deals with how much data you need in the application to render the technical effect achievable. And so this concept has been around for about 15 years now, and it's summarized on this slide here. It's not essential for an application to have experimental data or results, provided that the nature of the invention relies on a technical effect which is self-evident, predictable, based on a conclusive theoretical concept. In other words, it's plausible. And this originates, it's EPO's response to overly broad claims and to prevent speculative claiming. And this objection can arise in the context of sufficiency and inventive step. So for second medical use claims, as we have on this slide, compound X for treating disease Y, it has to be plausible that technical effect is achieved to meet the requirements of sufficiency. For a product claim where it's easy to actually make the product, this plausibility concept can still leave you in trouble, because it could be argued that it's not plausible that the product solves a technical problem, and you could go down for inventive step. It's important to realize that with second medical use claims where you're trying to argue that the claim is enabled, historically for enablement, it's up to the opponent to show that, to prove that a claim is not enabled, it doesn't work. Yet with this concept of plausibility in second medical use claims, the burden is reversed, and the burden is actually on the proprietor to show plausibility both during prosecution and opposition proceedings. I'm just going to finish by going through some case law that I think highlights the difficulties you can get into if you haven't met this plausibility threshold, but also some cases that you can cite during prosecution or contentious proceedings if you do find yourself in difficulty with this plausibility argument. So one of the founding cases was the John Hopkins case, and this related to a GDF9 protein that was purported to be a member of the TGF-beta superfamily. However, the applicant had no data in the application whatsoever or wet data to justify that. It was purely structural analysis data, some computational structural identity. The applicant did file some post-published data, so data that was filed after the filing of the application, to show that this GDF9 protein was indeed a member of the superfamily. But the board held that the post-published evidence may be used to support the solution to a technical problem only if it was plausible from the application as filed. And therefore, it's essentially saying if it's not plausible that the technical problem is solved from the application as filed, you cannot overcome that deficiency by filing data at a later date, for example, during prosecution. So something to be very much aware of. This is a later case by the Salk Institute. This case is a second medical use claim, and again, it was held that the post-published evidence can only be used to support the original disclosure and not as a sole basis for remedying an insufficiency of disclosure. If you do find yourself with a situation where you have filed early, you have no data, and you're worried that the examiner or an opponent is going to argue that it's not plausible that your second medical use claim is enabled, you can cite this T57806 decision, this Ipsen's decision, which I often cite in my practice. And here it related to somatostatin administration to improve survival of transplanted pancreatic islet cells. And despite the fact there was no wet data at all in the application, here the board actually considered that the disclosure of the experimental results in the application is not always required if the application discloses a plausible technical concept and there are no substantiated doubts that the claimed concept can be put into practice. So using this decision, if you face this plausibility argument against your own application, make it clear to the examiner or to a board of appeal or an opposition division that it's up to them to actually substantiate a doubt that the claimed concept cannot be put into practice. And if you have some mechanistic rationale in your application as to why the technical effect could be achieved, even in the absence of wet data, then you can argue that is enough to render the claim plausible. One thing to look out for in the European practice is this squeeze between inventive step and sufficiency when you're arguing for plausibility. Clearly, if you're arguing, well, we'll take a step back. For sufficiency, you could argue for sufficiency and enablement based on what's in the application as filed in combination with common general knowledge. So if you're struggling to identify plausibility based on the application as filed, you can refer to a common general knowledge document to further substantiate your argument for plausibility. But in doing so, be very wary that that common general knowledge document could be used in an inventive step attack against your claims. And I want to finish by just talking about an interesting case where the application had no data, yet notwithstanding that, they managed to argue for plausibility using common general knowledge and also avoided the inventive step squeeze. And so I'll briefly run you through this case. The application related to a compound as shown in this screen, and don't worry if you're not a biologist, the case law is quite clear without knowing too much of the technical details. There was a claim to the compound for use in treating or delaying the progression or onset of diabetes. And the drug was purported to work by targeting an SGLT, a sodium-dependent glucose transporter. But there was no data whatsoever in the application to show that the compounds could hit that transporter protein or that the compounds could be used to treat diabetes. So on the face of it, they were on a sticky wicket for plausibility. But the board did say in this case that they need to determine whether plausibility can be acknowledged in view of common general knowledge and prior art. And in this case, there didn't appear to be any prima facie serious doubt that the technical effect couldn't be achieved. And indeed, when the board looked at the application, there was a prior art document, D7, which referred to related compounds and suggested these related compounds could indeed inhibit the SGLT2 inhibitor, which was reported to be inhibited by the compounds of the application. And also this document cited 13 different patent documents that disclosed similar details. And so based on common general knowledge, it was plausible that the therapeutic effect could be achieved. And importantly, because the plausibility threshold had been met, the proprietor was allowed to file post-published data to further substantiate that point. And that becomes important when it came to inventive step. And one would think that if you're relying on common knowledge to show that the technical effect is achieved, then how are you going to get inventive step? But here, because the post-published data could be filed because it was deemed plausible based on the common general knowledge, in actual fact, the post-published data that they filed showed that the claimed compounds were actually better at inhibiting the target protein than the closest prior art. And therefore, when discussing inventive step, the objective technical problem was to provide improved inhibition. And on that basis, inventive step was indeed allowable. And so it's an interesting case, I think, where if you can argue for plausibility based on common general knowledge, that allows you to then file post-published data. And if you can show an improvement in a property with the post-published data, you may actually be able to avoid the inventive step sufficiency squeeze. So as we're running with the webinar, I'll miss out the last case and just summarize with some plausibility practice notes. Clearly, the timing of the filing is critical in order to obtain valid medical use claims. Does your application make it plausible that therapeutic effect is achieved? If not, it's difficult to file post-published data, so be very wary of that. If you have to file, and we all are under pressure to file sometimes due to a disclosure, and you have no data, it really does help your case on the European practice if you can include a mechanistic rationale in the application as to why the technical effect is achieved, because that can really help with plausibility without necessarily having to rely on common general knowledge. A final point I'd like to make is that we often ask, well, is it necessary to have data in the priority application or just in the later, for example, PCT application that claims priority? If you don't have data in the priority application and you're claiming second medical use claims, that can be terminal because the second medical use claims may not be deemed worthy of priority entitlement because they're not enabled at the filing date. However, if you have product claims in your priority application, then there's going to be no issue with enablement because in all probability someone can make the product. And if you then put the data in the later PCT application, that can support inventive step of your product claims. So in summary, the product claims in a priority application are far stronger in terms of a priority situation when you have no data in that priority application. And it's a bit counterintuitive because the product claims are actually broader than the second medical use claims. So it's still worth filing product claims even if you have no data in a priority application. Okay, I have whizzed through that fairly quickly in view of the time. So I hope you enjoyed the webinar. As Don said, if there's any questions, please do get in touch and have a great rest of the day. Thank you.